Carter Page and Team Trump were the targets of illegal spying. The FISA Court okayed search warrants for electronic surveillance based on lies told by the FBI and Justice Department.
Dirty cops, bad people.
Well, we were abused by the FISA process. There's no question about it. We were seriously abused by FISA.
The FISA courts should be ashamed of themselves.
Each of these FISA court judges issued a warrant in the Carter Page case. Were they snookered? Absolutely. But the FBI, NSA, and CIA have repeatedly misled the court in the past. Why does the court put up with that? Maybe the judges are too forgiving, as this former top FISA judge seems to be.
I don't think those are problems that I would call abuses. Mistakes were made.
Come again?
Mistakes were made.
Those mistakes were violations of the Constitution. Was anyone charged with a crime? No. We'll hear more from Judge Bates later, but first a little bit about the court. The Foreign Intelligence Surveillance Act, FISA, created the court. The act is designed to catch spies and terrorists without violating the Constitution. The FISA court issues search warrants based on probable cause. It also oversees spying programs that don't require a search warrant, and that's where there have been big problems. The FISA law allows spy agencies to collect and store emails and other electronic communications. The FBI, NSA, and CIA may use that information without a search warrant if they follow strict FISA court-approved policies. Policies that protect our Fourth Amendment rights against unreasonable government searches. Who checks their work? They're on the honor system. Every year, the agencies self-report to the FISA court. They explain what they did right and wrong. Their track record? Awful. Here we'll briefly review 3 FISA court opinions of that track record. Let's flash back to an October 2019 headline. FBI's use of surveillance database violated Americans' privacy rights. FISA Court Judge James Boasberg's 138-page ruling was highly critical of the FBI. The major conclusion: the FBI's procedures are not consistent with the Fourth Amendment. Now let's flash back to a 2017 headline. Secret Court rebukes NSA for 5-year illegal surveillance of U.S. citizens. FISA Court Judge Rosemary Collier's 99-page opinion also slammed the FBI. What did it do wrong? The FBI allowed contractors illegal access to NSA databases.
This opinion describes illegal activity by the FBI, illegal activity by contractors, and it calls it the improper disclosure of raw intelligence about Americans to unauthorized individuals. All of those things that the Bureau did and the contractors were crimes.
Wary of the FBI, Judge Collier wrote, "The improper access granted to the contractors seems deliberate. It was also an unwelcome surprise. The full scope of non-compliant practices had not been previously disclosed to the court." Note, Judge Collier refers to violations of the Fourth Amendment as a compliance issue, not a criminal matter. 3 years later, many questions remain. Who were the FBI contractors? Who were they spying on? Why were they spying? Was there a pattern? Was it political opposition research? Judge Collier knows she was hoodwinked, but no one was charged with a crime. She, the court, the FBI, and the Justice Department apparently just let it go. Now let's flash back to 2013 and this headline. Secret Court rebuked NSA on surveillance. The NSA collected tens of thousands of domestic emails of U.S. citizens, all in violation of the Fourth Amendment. FISA Court presiding Judge John Bates issued a blistering 85-page opinion. He criticized the NSA for repeated inaccurate statements over a 3-year period. He also wrote the agency frequently and systematically violated the court-mandated oversight regime.
And the agencies took it very seriously. They really looked carefully at these and to their credit, made adjustments as the courts required.
Judges rarely speak on the record outside the courtroom, but an internet search found this little scene clip with Judge Bates dating from 2014, after he left the FISA court. While it may look like an interview, it's not. It's just a series of softball questions from a friendly member of the legal community. Nevertheless, it's quite revealing. While critical of the intelligence community in his written opinions, he was very forgiving when asked about those Fourth Amendment violations.
I think those problems identified by various judges, including myself, in various compliance contexts are real problems. They were important problems. They're problems of concern to the judiciary and should be to the public.
Let's deconstruct his answer. First, neither Judge Bates nor any of the other FISA Court judges discovered anything. The agency self-reported the violations. Second, the judge considers the Fourth Amendment violations a compliance issue, not a criminal matter.
I don't think those are problems that I would call abuses by the executive branch, be it NSA or other entities within the executive branch and the intelligence community. I would call them failures.
Failures? You might call one or two violations of the Fourth Amendment failures. Thousands of violations is abuse. Abuses the judge sees as mere situations.
I would call them situations where the law wasn't followed correctly in all instances.
You heard right. He said the law wasn't followed correctly. Try that excuse on a cop the next time you're pulled over for a traffic violation. You'll get laughed at, but the judge said it with a straight face. Watch again.
I would call them situations where the law wasn't followed correctly.
The judge offered one euphemism after another for violations of the Constitution.
Situations where mistakes were made.
Mistakes were made. Mistakes were made. That's the oldest excuse in Washington and ensures that no one is to blame or punished for it.
Situations where mistakes were made, not intentionally, but because of errors in interpretation of court orders, errors in interpretations the courts ultimately found of the law.
Duly noted. Fourth Amendment violations are mere errors of interpretation. Nothing to see here. Move on.
They're of concern, but I would not say that they undermine the trust that one should have in the intelligence community.
He trusted the spy agencies even after they repeatedly lied to him year after year after year.
That while these issues were significant, I personally never felt that there was bad faith or intentional conduct by members of the intelligence community.
There's that phony issue of intent again. Who cares what the motive was? The fact is, there's been a pattern of illegal activity by the nation's spy masters before, during, and since Judge Bates served on the FISA Court. The law that allows surveillance without a warrant led to lawlessness. The result, the Fourth Amendment rights of hundreds of thousands, if not millions of Americans, were violated. Plainly, the FISA process is broken. Some people want to scrap it, others want to reform it. Whatever happens, all 11 FISA judges are surely embarrassed by the Carter Page case. That alone should result in greater scrutiny of future FISA warrant requests. Finally, a memo to the FISA judges. Stop coddling the deep state. When a federal official or contractor breaks the law, don't consider it a compliance issue. Treat it for what it is, a crime. Hold them in contempt of court. Demand the Justice Department file whatever other criminal charges apply. If you can't do that in defense of the Constitution, resign from the court. This is John Spiropoulos reporting.